The chair is authorized to declare a recess at any time pursuant to Committee Rule 2 and House Rule 11, Clause 2. The chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, to lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pursuant to notice, I call up the report recommending the House of Representatives cite United States Attorney General Merrick Garland for contempt of Congress and move that the committee report it to the House. The clerk will report the report.
Resolution recommending that the House of Representatives.
Without objection, the report will be considered as read and open for amendment at any point. The chair now recognizes himself for an opening statement. Special counsel Robert Hur stated on page 1 of his report, quote, "Our investigation uncovered evidence that President Biden willfully retained and disclosed classified materials after his vice presidency when he was a private citizen. Joe Biden not only kept information he wasn't allowed to keep, he shared it with people who weren't allowed to see it. He shared that information with his ghostwriter. Special counsel Hur said that President Biden had strong motivations to do so and to ignore the rules of properly handling the classified information in his notebooks. In fact, he had 8 million reasons to ignore the rules. Joe Biden shared some of the classified materials he kept with his ghostwriter, who was writing a book for which Joe Biden received an $8 million advance. So we have motive, $8 million motive, and we have the elements of the crime, knowingly keeping, knowingly disclosing classified information. But all this, and special counsel Hur declines to prosecute Joe Biden because he is, quote, a sympathetic, well-meaning, elderly man with a poor memory. And that brings us to today. Following the release of special counsel Hur's report, we subpoenaed the transcript and audio recordings of special counsel Hur's interviews with President Biden and his ghostwriter, Mark Zwanitzer. To date, Attorney General Garland has failed to produce the audio tapes. To determine whether special counsel Hur appropriately carried out justice by not prosecuting, not recommending for prosecution the president, the recordings are necessary. The transcripts alone are not sufficient evidence of the state of the president's memory. Frankly, because the White House has a track record of altering the transcripts. Just weeks ago, during a public speech, President Biden read a teleprompter instruction to pause. He stated, "Imagine what we could do next, 4 more years, pause." But when the White House put out the transcript, it didn't include the word pause. In that case, and in this case as well, the video and the audio recording is the best evidence of the words that President Biden actually spoke. The department's refusal to produce the audio recordings of special counsel Hur's interviews with President Biden amounts to a demand that the committee trust that the department created and produced interview transcripts are actually accurate and complete. Transcripts that the White House and President Biden's personal counsel likely had access to before they were finalized. The department has a legal obligation to turn over the requested materials pursuant to the subpoena. Attorney General Garland's willful refusal to comply with our subpoena constitutes contempt of Congress. Now today, this morning, we get an 11th hour invocation of executive privilege. President Biden is asserting executive privilege for the same reason we need the audio recordings. They offer a unique perspective. This last-minute invocation does not change the fact that the Attorney General has not complied with our subpoena. With that, I would recognize the ranking member for an opening statement.
Thank you, Mr. Chairman. 20 million taxpayer dollars. Chairman Jordan, who consistently opposes government spending on everything from feeding children to education and health care, has spent 20 million taxpayer dollars of this Congress to investigate his various conspiracy theories. And what exactly has he delivered to the American people on their $20 million investment? Exactly nothing. No evidence that the conspiracies are true, no indictments, no impeachment, no wins of any significance. If the chairman of a board of directors took $20 million from the shareholders of a company and delivered nothing, he'd be fired at the next board meeting. And the chairman knows that if he doesn't come up with something to show for the $20 million he spent, the MAGA political base may stay home next November. So he and Chairman Comer are scrambling in a desperate attempt to look like they have accomplished something. The chairman wants to make it seem like he uncovered some wrongdoing by the Attorney General. In reality, the Attorney General and DOJ have been fully responsive to this committee in every way that might be material to their long-dead impeachment inquiry. Sometimes they've been too responsive, in my opinion, given the obvious bad faith of the MAGA majority. The chairman was desperately hoping that Special Counsel Hur would indict President Biden for mishandling classified documents, so that the chairman could attack President Biden and misdirect the American people away from Trump's treacherous handling of classified information. In reality, the special counsel cleared Mr. Biden of wrongdoing. The chairman hoped he could intimidate prosecutors out of indicting Donald Trump for his crimes, but Donald Trump has been charged with 88 felonies. The list goes on and on. The chairman digs and searches and intimidates, but there's just no there there. So what do our Republican friends do when an investigation turns up short? Simply put, they engage in fantasy. That's what they are doing here today. They accuse the Attorney General of withholding key evidence, but the Attorney General has substantially complied with their every request. DOJ has produced 92,000 pages of documents this Congress alone and made dozens of witnesses available for interviews, hearings, and briefings before the committee. That's more pages of documents and more witnesses than the Trump Justice Department produced to this committee in 4 years. With respect to the February 27th, 2024 subpoena, the department turned over all the information Republicans asked for. There's been no obstruction, only cooperation. This morning, the President exerted executive privilege over the audio files at issue. In the letter informing the committee of this assertion, the Department of Justice noted that producing the audio recordings would, quote, raise an unacceptable risk of undermining the department's ability to conduct high-profile criminal investigations. In particular, investigations with the voluntary cooperation of the White House officials is exceedingly important, close quote. Chairman Jordan claims that he needs this records to understand the pauses, pace, and tone of the conversation. This is absurd and clearly pretextual, and in any event does not outweigh the substantial concerns expressed by the President and the Department. Moreover, with respect to the recording at issue in this report, a complete transcript has already been provided to the committee. The only thing that has not been produced is the recording itself, which can be easily manipulated. This is not an idle concern. Last year, a witness testifying in a closed-door deposition told us that she was the victim of a manipulated video amplified by Republicans on this committee and that it contributed to a flood of death threats against her. This isn't really about a policy disagreement with the DOJ. This is about feeding the MAGA base and getting Donald Trump reelected. But don't take my word for it. Take it from the chairman's mouth. Quote, I'm busting my tail to get Donald Trump reelected. Quote, we need to make sure Donald Trump wins. Quote, it's so important that we stay engaged and help Donald Trump get back in the White House. Close quote. And clearly, Donald Trump needs the chairman's help to win the White House. Because Trump has been indicted 4 times. Right at this very moment, he faces 34 charges in a New York State court for falsifying business records and making hush money payments to catch and kill information that could be harmful to Trump's reelection campaign. He faces 40 charges in a federal court in Florida for his mishandling and withholding of classified documents that put national security at severe risk. 4 charges in a federal court in Washington, D.C. for his attempts to overturn the 2020 election results and fueling the insurrection on January 6, 2021 at the United States Capitol. 10 charges in Georgia State Court for attempts to intimidate and force officials to overturn the lawful election results in the 2020 presidential election. And that's not all. You're going to hear a lot about President Biden's memory today. Republicans won't mention that Biden has been ranked as one of the most successful presidents of our time. They won't mention the once-in-a-generation transformative legislation he has ushered into law. They won't mention Special Counsel Hur's comments to President Biden about his, quote, photographic, unquote, memory. They'll just go on and on about a couple of gratuitous, widely contradicted comments in the Hur report that suggest the president has a poor memory. What Republicans won't show you is the mounting evidence that Trump is mentally incompetent to hold the office of the president. The late, great Hannibal Lecter. I can't even begin to understand how Republicans have chosen this man as their champion, but they have. And now House Republicans are paying for it by flocking to the sidelines of his criminal trial, sacrificing their integrity to defend him against, frankly, indefensible acts. Almost everybody who worked for the former president seems to know that Trump is unfit for office and that these acts of public humiliation on his behalf are wrong. What more evidence do my colleagues need? Trump once said that he could shoot someone standing on Fifth Avenue and would still keep his supporters. Well, at least in this chamber, that's obviously true, and it truly saddens me. I've been in this body for many years, and although we've always had our disagreements, I've never seen members of Congress so readily turn on democracy itself in service to one man. I never in my life thought I'd see members of Congress readily attack law enforcement officers to protect a criminal. I never thought I'd see members of Congress defend and minimize a coup attempt, as if the rioters who stormed this building and the Trump associates who led them here were somehow patriots. But here we are. I think Chairman Jordan knows that this markup will amount to nothing. Like most of the bill's House Republicans have pushed on purely partisan lines, this contempt resolution will do very little, other than smear the reputation of Merrick Garland, who will remain a good and decent public servant no matter what they say about him today. This markup may give Donald Trump something to watch on Fox when he gets home from his criminal trial tonight, but it will almost certainly not convince the Department of Justice to produce the one remaining file in question. Like the broader impeachment effort before it, this contempt resolution will have been a partisan stunt destined to fail from the very start. It is a total waste of time. The American people actually need us to do important work, to fund the government, to secure affordable health care, to reduce inflation and housing costs, to help them take care of their children and families, and to keep our nation safe. I'm tired of these games, and so are the American people. I urge my colleagues to oppose this measure, and I yield back.
Gentleman yields back. Chair to recognize himself for the purpose of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to the committee report.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes himself to explain the amendment. This amendment makes a small grammatical change on page 10 of the report. It does not affect the substance of the report. I yield back. Who seeks recognition? Question? Gentleman from North Carolina is recognized.
Thank you, Mr. Chairman. This is a very simple matter. There is no ground whatsoever to withhold the audio tape. That tape must be quite something. If the administration, if the president has decided to assert executive privilege to keep it from the committee in the course of an impeachment inquiry, think about it. The basis for withholding the audio recording when the transcript has been furnished must rest on something about the recording that is distinct from the information contained in the transcript. For example, what if the committee had made a request for just a different copy of the transcript? Now, that's unlikely to happen, but no reasonable person would ask for it either. The president and the White House have contested what was said in the interview. The special counsel, in his report, predicated his decision not to prosecute an obvious violation of statute in the president's reading from classified information to his ghostwriter to satisfy the terms of his $8 million book retainer, on his finding that the president was elderly and forgetful. In other words, he placed tremendous reliance on what is called demeanor evidence. The president and the White House have viciously attacked the special counsel's characterization of the demeanor evidence. That is, whether and to what extent the president appeared to have limited capacity as a witness to testify from memory. Now, the transcripts do not capture demeanor evidence. Transcripts are often imperfect, especially to convey the timing of question and answer and disfluencies of a witness or hesitations, among other things. All of that is demeanor evidence. That's the reason, among other things, that it is absolutely standard practice in litigation in American courts for parties to be entitled to record testimony by more than one means, through a transcript, and then if they choose, through another method, an audio or video recording. Here's a reading from Rule 30b-3b of the Federal Rules of Civil Procedure. Any party may designate another method for recording the testimony in addition to that specified in the original notice. It's pretty straightforward. Given that the evidence is contradicted by the special counsel and by the president as to the reason the president has escaped criminal prosecution for an obvious violation of statute, and because this committee sits by vote of the House of Representatives to conduct an inquiry about the potential impeachment of the president, this committee needs the demeanor evidence the same way any party would in any such matter being litigated. And the notion that there is a basis for a claim of executive privilege here, and what has been articulated by the Justice Department, by the Attorney General, is that it would deter future occupants of the White House from cooperating with criminal inquiries because the interview would be made available and therefore it was going to be exposed, but the transcript's already been provided. What possible basis could there be that would impair future White House cooperation with criminal investigations if what the department is contending is just the same information in an audio recording form is also furnished? That is an incomprehensibly absurd position. And so there's nothing to it whatsoever. This committee cannot be deterred in proceeding with the contempt resolution, in my view. And one can question motives or attack motives or whatever, but it's just as straightforward as it can be. It's a simple presentation of demeanor evidence that is important to this committee's investigation, inquiry into the potential impeachment of the president, and it should be accomplished and done forthwith. I'm for it. Let's go. Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from
Chairman.
the ranking member is recognized.
What? Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Merrick.
Point of order reserved by the gentleman from California. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, this amendment adds language from the most recent correspondence with the executive branch to the report. Today, the Justice Department and the White House wrote to the committees to inform us that the president was exerting executive privilege over the audio recordings. This assertion of privilege is used to protect important law enforcement interests. As the Attorney General wrote, the Justice Department has a vested interest in protecting, quote, materials related to a closed criminal investigation where disclosure is likely to damage future law enforcement efforts, close quote, which is the case here. The Attorney General further explains that producing the audio recordings to the committees would raise an unacceptable risk of undermining the department's ability to conduct similar high-profile criminal investigations, in particular investigations where the voluntary cooperation of White House officials is exceedingly important. The White House also wrote to the committees to explain that the President's exertion of executive privilege is based on his, quote, long-standing commitment to protecting the integrity, effectiveness, and independence of the Department of Justice and its law enforcement investigations. Chairman Jordan claims he needs these recordings to understand things like tone or pauses. This is absurd, and the chairman has made no attempt to explain his reasoning. His claim in no way overcomes the executive branch's substantial interest in protecting sensitive law enforcement investigations. What high-profile witness would ever voluntarily cooperate with a law enforcement investigation if they knew that audio files of their conversations would be released to committees who are seeking those files for purely political purposes? This amendment simply ensures the report is complete and up to date. I urge my colleagues to support the amendment, and I yield back.
Gentleman yields back. The gentleman from California withdraws his point of order. The gentleman from North Dakota is recognized.
Thank you, Mr. Chairman. I move to speak in opposition to the amendment. They don't get to choose. They don't get to choose. We spend a lot of time in this hearing, in this room, talking about, I've been an advocate for recording interviews, recording arrests, doing all of this. There's a pretty known legal precedent and legal rule of the best evidence rule, and it exists everywhere. The person providing the evidence doesn't get to choose the manner and form in which the evidence is provided. And this also happens to be a pattern. 5 minutes before the Her hearing, we got the transcript. 5 minutes before this hearing, we get the invocation of executive privilege. There's a difference between a transcript and a video and audio. And I don't possibly understand the argument of, we'll release the transcript, but we won't release the tapes, and that's going to determine whether or not somebody participates in an investigation, which, by the way, that can be compelled to be done as well. The argument that this is somehow anything other than the DOJ trying to pick and choose which pieces of evidence or which parts of evidence are what they determine is the best evidence to our committee is just, quite frankly, not based in any precedent under law. I spent 10 years doing this. I spent 10 years doing discovery requests. I never asked for permission. I'm entitled to what it is. They don't get to determine what we get. That is not how the system works. And it can't be how the system works. Because otherwise, the people who you are trying to conduct oversight on determine what information you get to conduct that oversight. That is just simply not how the separation of powers is set up. It's not set up in how any legal investigation in any jurisdiction in any form exists anywhere in the country. The audio tape exists. That is the best evidence in which to conduct oversight, and this committee is entitled to it. And with that, I yield back.
Gentleman yields back. Who seeks recognition? The gentleman from California.
Thank you, Mr. Chairman. I speak in support of the amendment. But first I want to talk about both what this committee and what this Congress is doing to the rule of law. Earlier this week, we witnessed the spectacle of the highest-ranking Republican in the country, the Speaker of the House, someone in line for the presidency, standing outside a Manhattan courthouse in a hush-money payment to a porn star trial, vouching for the good moral character of the defendant. Now, I would imagine if you asked a younger Mike Johnson some 10 or 15 years ago, could you ever imagine you would stand outside of a courthouse in a hush-money payment to a porn star trial and vouch for the moral character of the defendant? He would never imagine that possible. But like the proverbial frog in the boiling pot, what we have seen, not just with the Speaker, but with so many of the Republican leadership over the last several years, is one surrender of moral authority after another surrender, one betrayal of what one once stood for, followed by another betrayal, followed by another, until you find yourself standing outside of a Manhattan courthouse, vouching for the moral authority and character of someone who possesses none. And not just losing yourself and losing any sense of right and wrong in the process, but here denigrating the very institution of justice, making the false claims, the patently false claims that this trial in Manhattan was somehow about keeping Donald Trump off the campaign trail, something the Speaker knows is patently false, but willing to repeat. And this is where we are, where our highest ranking official, Republican official, is essentially telling the American people, don't trust our system of justice. Don't trust the rule of law. And here in this committee, we see something very similar. We see a Republican U.S. attorney brought on to investigate the president. We see him make a report to this Congress that there is nothing prosecutable in what he was able to find. We see him at the same time failing to make a prosecutable case, deciding the next best thing he can do is lob a political grenade in his report and politically belittle the president. And we see this committee unable, after months and months and millions of dollars to make any kind of an impeachable case, decide to follow Mr. Hur's tainted example. We can't make a case for any impeachment. There is no high crime. There is no misdemeanor even. And so we will do the next best thing, and we will use this to political advantage by subpoenaing tapes of an interview we already have the transcript for. And why? Because the Republicans in this committee have moved from being the criminal defense firm for the president to being essentially an adjunct of the president's media advertising firm. They want the video for Donald Trump's campaign commercials. That's where this committee has become, the Committee on the Judiciary, the committee that is centered or supposed to be centered on the rule of law and on justice. And what are we doing? We're holding the Attorney General of the United States in contempt. And for what? Because he won't give video material for a campaign commercial to this committee on behalf of a president who is a criminal defendant in a hush money payment to a porn star case in New York, the first of many criminal trials that he will face. This is where we are. This is where we are. I first joined this committee, now it's been over 20 years ago. And I suppose like a young Mike Johnson, I could have never imagined this committee would engage in such a thing. It's not as if 20 years ago this committee was some bastion of bipartisan comity. It wasn't. We might and did disagree on abortion and on guns and on the whole host of other policy issues. But I don't think any Democrat or Republican on this committee would have ever imagined it would be brought so low as to hold an attorney general in contempt because it can't get a video for a campaign commercial when it was already given the transcript. But this is where we are. And I think just day after day, moment after moment, year after year, we lose sight of how far we have fallen and any sense of what we are supposed to be about in this committee. And I don't imagine anything I have to say is going to change that, but I do think every now and then the country needs to be reminded that there is nothing okay about this, there's nothing right about this, there's nothing normal about this. We need to get back to demonstrating some devotion to our constituents and the rule of law. And with that, I yield back.
Gentleman yields back. The gentleman from New Jersey is recognized. Will the gentleman yield for a second?
I will yield.
Yeah, I just want to point out, we're not seeking a videotape. We're seeking the audio tapes to correct the statement from the gentleman from California. And the Democrats, I believe, held the Attorney General of the United States in contempt a couple Congresses ago when they held Bill Barr in contempt. I yield back to the gentleman from New Jersey.
Thank you, Mr. Chairman. Look, we got to get focused here. The gentleman from California, he's kind of, again, trying to take our eye off the ball. This has nothing to do, this particular issue right here, what we're doing with the courthouse in New York City, this doesn't have anything directly to do with what is going on with President Trump there. And I would be glad to engage in a colloquy or a debate or discussion about how awful what's happening to President Trump is, but that's not the issue here right now. This has nothing to do with the campaign. It has nothing to do with the fact that the speaker did go, as he should have, to support President Trump. But this isn't the issue. It has to do with special counsel Hur, and it has to do with what he said. And by the way, he never said it wasn't prosecutable. He decided not to pursue the charges due to the assessment that a jury would find President Biden's age and poor memory as an excuse for mishandling those documents. I didn't say that. Our chairman didn't say that. The special counsel from the Department of Justice said that. The subpoena of the Attorney General is necessary because the Department of Justice has refused to provide the audio recordings of interviews that are crucial for determining the special counsel's assessment of our current president. It's essential for this Congress and the American people to determine whether special counsel Hur's assessment is accurate or not. And I'm going to tell you why. And the folks on the other side and the left here are in a bind. Because if our commander-in-chief is so incompetent that he cannot stand trial, he's not fit to stand trial, then he's too incompetent, for God's sake, to be the leader of the most powerful nation on the face of the earth. If President Biden is competent and special counsel Hur's assessment was incorrect, then President Biden should face a jury for his crimes of mishandling classified materials. You know, President Trump's facing the full weight of the Department of Justice in his own case on this issue, even though he had the authority to declassify documents because he was the President of the United States when he did it. President Biden, on the other hand, mishandled classified documents, both as a vice president and then as a senator. Guess what? Members of Congress, vice presidents, U.S. senators don't get to take classified documents and remove them from the SCIF. They just don't get to do that. They don't get to declassify documents. He didn't have the authority to declassify. So the audio recordings, why do we want them? Because they're going to reveal whether special counsel Hur's assessment was correct and our president mishandled classified documents, or it will reveal he's incompetent and he's not competent enough to even stand trial, and therefore not competent enough to be the president of the United States. That's the choices we have. We've got two choices here. He was competent and he broke the law, or he's incompetent and he's so incompetent, he's such a bumbling old man that he can't even stand trial because they wouldn't really be able to do much with him. That's what we want to find out. That's what we need to know. Either way, it'll be clear our president is unfit to lead, in my opinion, and likely why the DOJ is so damn hesitant to share it. I'll tell you what, anybody else, probably anybody on this committee, if you ask them to share the audio of something we said, believe me, anything I'm saying now you can share anywhere. And you can share anything the chairman says or any of our esteemed members say here on either side. So why don't they want it? They've got a reason, because they're in a bind. And am I willing to set the precedent that subpoenas from Congress and this committee can be ignored? Are you willing to do that? I don't think so. I don't think that we want that to happen. Are we willing to perpetuate, if the president is competent, a two-tier justice system? Again, we see it again, being wielded against one person but not another? The answer to the question should be no. The information requested in this subpoena is crucial. We need the information, not just for uncovering whether our president has acted in a manner deserving of impeachment, but also because the American people deserve to know the answers. We shouldn't be hiding the answers and the truth from the American people. For those reasons, I don't support this amendment, and I do strongly support holding the Attorney General in contempt of Congress. Let it loose. Give us the information. If there's nothing there to worry about, you should have no problem letting us know and letting us see. Let the light in. Let the sunshine in. I yield back.
Gentleman yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I want to address a couple of things quickly before I get to the amendment. But one of the arguments I'm hearing from the Republican side over and over again is essentially questioning Mr. Hur's conclusion not to move forward with a prosecution. But I did want to remind my colleagues that under, Mr. Barr, the Department of Justice has taken the position that the committee, referencing this committee, the House Judiciary Committee, has no legitimate role in demanding law enforcement materials with the aim of simply duplicating a criminal inquiry, which is, of course, a function that the Constitution entrusts exclusively to the executive branch. So to the extent you're arguing that you don't agree with his findings and you want to sort of replicate them or go through them again, Mr. Barr argued against that 5 years ago. With respect to the underlying amendment, or the amendment to the ANS, there's a major problem here with moving forward with the language in the amendment, because it's based on the predicate that, and I'll read it, to the date the department has refused to produce the audio recordings despite not having invoked any privilege to justify its failure to comply with the subpoena. And one of the conclusions that it reaches at the end, as a justification for moving forward with contempt, the Attorney General has further invoked no constitutional or legal privilege relieving his obligation to fully respond to the committee's subpoenas.
Gentleman yield?
Sure.
Yeah, we're drafting an amendment. We understand that has to be dealt with in light of the last-minute executive privilege assertion coming from the White House. So we are drafting that amendment, but we are running it past House Counsel. So the majority intends to offer an amendment for the specific language that the gentleman cited.
Will the committee then adopt the ranking member's amendment?
No, we have our own.
Well, I guess we'll have to take a look at it when it gets here. But, you know, moving forward on this basis, even if you amend the language and add that, I want to remind the committee that where there's an assertion of executive privilege, according to Nixon, which is the case that you all have cited, I don't know if you're going to strike that too, but upon receiving a claim of privilege from the chief executive, it became further the duty of the district court to treat the subpoenaed material as presumptively privileged and required the special prosecutor to demonstrate that the presidential material was essential to the justice of the case. And that's because it was a pending criminal case, so moving forward at that point, so there's an expedited process. We obviously don't have an expedited process here, but just to point out and be clear about this, the court said this is presumptively privileged. And so moving forward as if that's not the case, I think is deeply problematic. One of my colleagues over there a minute ago said something about you don't get to choose, but that's exactly what happens when you assert a privilege, especially executive privilege. And the references from the other side with respect to regular civil litigation, which is fine, I engage in regular civil litigation too, but this is litigation between the Article I and Article II branches of the United States. This is constitutional magnitude. So rushing through this quickly, I think, is misguided, and I think it'll lead to, hopefully, a court telling the committee that we're going down the wrong track, we're abusing our power for oversight, especially in the instance where we've got a special counsel that's already been appointed, has reviewed the issues, has come back and stated clearly that there's insufficient evidence in his view to move forward with the prosecution. And I think it's especially problematic too if we have to take it to a court again, that there's no evidence here of a refusal to cooperate. In fact, you've got the exact opposite. The above and beyond language in the Barr language, in the Barr letter, is clearly met here too. We've got Mr. Garland. He wasn't legally required to release the report, but he did. He wasn't required to release the transcript, but he did. And as was pointed out a minute ago by the ranking member, the department's produced 92,000 pages of documents. We've had, I don't know, 40 or 50, lawyers from the Department of Justice come and testify, a couple of them in the middle of a criminal prosecution, which is totally unprecedented. So for these reasons and more, I'm urging my colleagues to rethink this approach, because I think ultimately it's going to end up in undermining the ability of this committee to conduct legitimate oversight at the times when that's appropriate. So I've exceeded my time. With that, I yield back, and I thank the chairman.
The gentleman yields back. The gentleman from Alabama is recognized.
Thank you, Mr. Chairman. I yield to Mr. Armstrong.
Thank you. Couple things. One, I would be happy to argue this because and to my colleague from Maryland, I wish you'd have been here in May of 2019 because we legitimately, as the chairman said, we held the Attorney General in contempt after exerting privilege, but it was more than that. We held him in contempt for not violating the law.
Right.
Like there's actually a statutory requirement that you can't disclose grand jury testimony. So if we talk about the path we're going down and continue and talking about oversight, we don't have to go back to Nixon. We can go to May of 2019. And so to my colleagues on the other side of the aisle that are arguing about this, I would love to get that transcript or audio or video and come back out here. But we're not duplicating a criminal proceeding. There is no criminal proceeding. We got the answer from where we're at. And if you talk about I'd argue this if we go in front of somebody and say, of course they're doing it. They're running out the clock. Like, he could have exerted executive privilege, I don't know, a week ago, a month ago, 6 weeks ago. It's a pattern that is going on with this DOJ and this White House, that as we come up to the precipice of when you're actually going to do something, then they say at the absolute last minute, they drop all of this. And we have a right to do these things. And I fully am aware that the difference between a criminal prosecution and a civil litigation and a congressional hearing are the same thing. But the basic premises of what is the best evidence, what we are entitled to versus what the opposing side says we are entitled to, is something I think the people on my side of the aisle are completely willing to have that conversation with whoever is an independent and neutral arbitrator of those facts.
Will the gentleman yield?
Sure.
You know, the best evidence standard, which I don't think is necessarily applicable here because it's not a court proceeding, and the demeanor evidence things I think fell on their face for the same reasons. But the point here, I think, though, is with respect to the 6E issue, it can be waived and routinely is as a matter of practice, and certainly has been for Congress. So, you know, I don't know that that's a real good analogy. But the bottom line here, though, is you guys are arguing you need it for demeanor evidence, which again has no applicability here because it doesn't go to the finding that came from her or the impeachment transcript. And really, this altering the transcript is really what you have to argue. In fact, the chairman argued that. But there's absolutely no evidence of that. In fact, it's a certified transcript. This isn't one that was somebody typed it up on the side. These are the transcripts that we generate on a routine basis in Congress and the Department of Justice.
Reclaiming my time, that's not my, that might be somebody else's argument. That's not my argument. My argument is if I have the version of going through something and dealing with something and all of those different things, I have watched witnesses in this committee in depositions say things because they know they've agreed to it not being released on video. How something reads and how something sounds is different. That is true. And I'm not arguing that I'm not saying what they're entitled and not entitled to give me. I'm saying I'm entitled to this evidence, and I think this hearing is entitled to it, and I'm willing to have that fight. I have never been in my entire life said, okay, you tell me what I get, and I'll just agree to that. And that's not the point. And regardless of all of the other issues, you don't get to say at the last minute, we're exerting executive privilege because nobody will ever come and voluntarily come into an investigation ever again, because if we release the audio recording instead of the transcript, that's gonna have a chilling effect. That is a ridiculous argument. I don't care what the burden of proof is, it's just a ridiculous argument.
Will the gentleman yield again?
Yeah.
I mean, that's an argument that's been raised administration after administration after administration, including by the Trump administration on multiple occasions. The assertion of executive privilege is at least 50 to 60 years old. And that is based on a decision by the executive branch, usually the Department of Justice, to make a decision as to what they'll turn over and what they won't. And if it has to get litigated in court, then the court decides. But this is exactly how it's supposed to go.
Except executive privilege is usually done whether or not you get the information or not. I was here, I remember when the Attorney General came in and said, I can't turn this stuff over because I will be breaking the law. This isn't a matter of whether they're turning it over or not. We already have whatever you think it is. They're saying, we're only gonna give you the piece of it we wanna give you. We're not gonna give you what you guys want. And that's the fundamental disagreement that exists here. We want the evidence of what happened, and the best evidence available is the audio tape. And with that, I yield back.
Gentleman yields back. Gentleman from Alabama yields back. The gentleman from Tennessee is recognized.
Thank you, Mr. Chair. I have been despairing the state of our country, but even more so the state of this committee and the judiciary for the last several months. This committee is becoming the Eileen Cannon Committee, the Trump-anointed group to support him and defend him for conduct that is not defensible and to put roadblocks in the path of justice where he should be on trial in Florida for his keeping classified records. He didn't declassify them, he just kept them. And this is a man who several of our colleagues went to New York and said that our rule of law was false, that this case in New York was political and shouldn't have taken place. The thing we're most respected for around the world is the rule of law. People envy us for our rule of law. And to have people who know better go and trash it is despicable, almost treasonous. And then this committee, the hypocrisy that this committee would question Merrick Garland, who appointed a Republican to look into President Biden's conduct, a man who Mr. Hurst said he was here to be questioned. Anybody here could have questioned him about the conduct of what Mr. Biden said and why he came to that conclusion. But he said he was a sympathetic elderly man with a poor memory. The fact that he was sympathetic is why he would not be convicted, as distinguished from his forthcoming opponent and past opponent, who is a despicable, mendacious man with a poor knowledge of history and government and a poor memory to boot. A man who his own Secretary of State said was a moron. Yes, Tillerson said he was a moron. Kelly said he admires, John Kelly, his chief of staff, said he admires autocrats and dictators and has no conception of the rule of law or concern for it or for democracy in our country. His defense secretary, Mark Esper, said he was a threat to democracy. John Bolton declared him to be unfit to be president. And of course, Mike Pence said they had profound differences. All folks coming up here and defending what's going on in New York. This is a man who had just, his wife gave birth to his child, and he was playing golf and fornicating in Nevada rather than being with his wife and his newborn child. What an example we have for the American public and for young people. Joe Biden is, as Colin Yost said at the Correspondents' Dinner, a decent man. He's sympathetic and a decent man. And the idea, one of the gentlemen said, we're in an impeachment hearing. We're not in an impeachment inquiry. These are just things they've thrown out there to try to take the facts away that he was twice impeached and to try to impeach
Would the gentleman yield?
Biden and Mayorkas. Both were wrong. And the hypocrisy that almost, I think every Republican on this committee voted against holding Barr in contempt, and that one of our members, my friend, the chairman, was cited for contempt because he refused to appear before a committee dealing with January 6th and the overthrow of the government. The hypocrisy is voluminous, and I yield to Mr. Nadler.
I thank the gentleman for yielding. I just want to point out that the discussion we heard before about best evidence and so forth between Mr. Armstrong and Mr. Ivey is fit for a criminal trial. But this is not a criminal trial. This is a dispute between the executive branch and Congress. And in such a dispute, Congress must show a need for the evidence that we seek. Republicans have not made that showing. They've shown no need for these files. So the discussion we heard before is irrelevant because it was dealing with a criminal trial. This is not a criminal trial. This is a dispute between the executive branch and Congress. And in such a dispute, Congress must show a need for the evidence that they seek. Republicans have not made that showing. They have not shown any need for these files, and that renders this whole thing ridiculous. And I thank the gentleman for yielding, and I yield back to him.
Thank you. In my last 10 seconds, all I can say is, God bless America, because we need somebody of that authority to bless us with the way this committee and these folks have dealt with this case and ruining a constitution and democracy.
Gentleman yields back. The gentleman from California is recognized.
Thank you, Mr. Chairman. Since the discussion's drifted into the Manhattan trial, I just have to say that it's ironic to hear my colleague from California speak to the integrity of our legal system, Like most Americans, I am appalled that our justice system could become so dangerously politicized. It started with the IRS harassing members of the Tea Party years ago. Then we had the FBI and intelligence agencies using what they knew was a completely fabricated story by the Clinton campaign over Russian collusion. My colleague played a large role in that and was censured by the House for his role in it. Then we had the intelligence agencies concoct the lie that the Hunter Biden laptop was a Russian hoax, and that may have decisively affected the outcome of the 2020 election. And now we have these sham cases against Donald Trump on the flimsiest of legal grounds, grounds that have never been charged before, and with the obvious intent to interfere massively with the presidential campaign. The sinister nature of these cases is that it doesn't matter that they're falling apart. That's not the point. The point is to drain Trump of his time and resources and throw the election to the Democrats. Now, the cornerstone of our justice system is equal justice under law, that no matter who we are, we're treated the same. That's why justice is depicted as blindfolded. And in each of these cases, there seem to be three standards of justice, one for Donald Trump, one for the rest of us, and then one for the Democrats. And that strikes at the heart of the matter before us, the decision to prosecute Donald Trump for mishandling classified documents and the decision not to prosecute Joe Biden for the same offense. Now, executive privilege is an important concept, has an enormous bearing on the separation of powers. The discussion, in fact, it goes back to George Washington's administration. And the discussions that a president has with his advisors or subordinates in the executive branch on any matter within the powers of his office are no more the business of the legislative branch than the discussions among members of Congress are the business of the executive. The president cannot compel Congress to divulge its deliberations any more than Congress can compel the president. So it's crystal clear to me that any official discussion between the president and any subordinate cannot be pierced. But this case is very different because it's not a conversation between the president and a subordinate over policy or the discharge of his official duties. Rather, it's an interview in the course of a criminal investigation. To me, this is far closer to the Nixon tapes. The Nixon tapes were not conversations as part of a criminal investigation, but conversations that had bearing on one. The conversation in this case is even further from the root of the executive privilege. This was an interview in a criminal investigation that clearly falls within the legitimate legislative function. It's not only a legitimate inquiry, it's a vital inquiry. How is it that there are two cases involving the handling of classified information that have been treated so radically differently? As President Donald Trump had absolute authority to declassify material at will, as Vice President, Joe Biden did not. Under the Presidential Records Act, President Trump had absolute discretion to determine what papers to retain in the course of his presidency. As Vice President, Joe Biden did not. And yet a decision was made to prosecute Donald Trump and yet not to prosecute Joe Biden by the Joe Biden administration. So it bears repeating, the foundation of our judicial system is equal justice under law. Without this, the law loses its moral authority. It simply becomes raw political force. And it's apparent to me that we are moving dangerously away from this principle of equal justice. Congress has an essential role to play in setting things right before we lose the very principles that define us as a free people. And central to this is to understand why these two cases were treated so very differently. The request of the administration is legitimate, and the contempt citation for its refusal to provide this information is entirely appropriate. And with that, I yield back.
Well said. The gentleman yields back. The gentleman from California. I have California, then I'll come there. The gentleman from California, Mr. Lewis, recognized.
Thank you, Mr. Chairman. The House Judiciary Committee is responsible for helping to ensure the rule of law. Unfortunately, the actions of this committee chairman in ignoring a bipartisan congressional subpoena has hurt the ability of this committee to get information and hurt the rule of law. It is a height of hypocrisy for the chairman of this committee to try to enforce a contempt subpoena against Merrick Garland when this chairman himself ignored a bipartisan congressional subpoena. Now, I've been to a number of proceedings in my time in Congress and in the state legislature that have been relatively stupid. But this proceeding goes beyond stupidity. It is a waste of taxpayer resources. Why is that? Because we have the transcript. We have the transcript of the interview between Special Counsel Robert Hur and President Biden. There's no evidence whatsoever that this transcript was made up, that it's fake, that it's been doctored. This transcript was produced by Robert Hur's office. Robert Hur was appointed by Donald Trump. He is a Republican appointee. The notion that somehow this transcript is fake is a wild, insane conspiracy theory. You know what I think is really going on? Joe Biden stutters. He's always had a stuttering problem. He was made fun of as a child because he stuttered. He was bullied as a kid because he stuttered. He overcame stuttering to become president of the United States. And Republicans in the past have used his stuttering to smear him. I think that's what they want to do again with this audio. I think that is despicable. And if Republicans are going to go low, I am going to punch back. So let's talk about Donald Trump. I agree with the Republican from New Jersey who said if a person cannot stand trial, he should not be president of the United States. Donald Trump has fallen asleep multiple times at his own criminal trial. I am a former prosecutor. I can tell you that is not normal. I think there may be some physical and mental health issues that should be investigated. I'm going to tell you what people in the courtroom are writing about Donald Trump falling asleep. Here's a reporter who has been observing this. One reporter observed, quote, that Donald Trump has nodded off a few times, his mouth going slack and his head drooping onto his chest, end quote. Another reporter said, quote, that Donald Trump slowly dropped his head. His eyes closed, it jerked back upward, he adjusts himself, then his head droops again, he straightens up, leaning back, his head droops for a third time, he shakes his shoulders, eyes closed still, his head drops, end quote. If a person is so weak and feeble, if Donald Trump is so weak and feeble, he cannot stay awake at his own criminal trial, he can't be president of the United States. So instead of going around trying to smear different people, why don't we work on a bipartisan basis on issues that matter to the American people? Like, how about let's do a bipartisan hearing and let's do some bills to fix our broken immigration system. But the Republicans here don't want to do that. They don't want to work on a bipartisan basis. They don't want to fix this. Why? Because Donald Trump told them not to. Well, okay, so how about another issue? Let's talk about high prices. Prices are high. We did get a good report yesterday that inflation has now slowed down. That is good, but prices are still high. Why don't we work on bipartisan basis to look at price gouging? We have companies making record profits. They're gouging consumers. Let's have a hearing on that. Why don't we have a hearing on that? Because Republicans don't want to fix this issue. They want it as a campaign issue. Okay, then how about let's do a topic that isn't a campaign issue. Artificial intelligence has now become prevalent in many places. It could have privacy implications. It could do amazing things. It could also harm us in a variety of ways in terms of bias and so on. Why don't we do a hearing on this in this committee? Why don't we do that? Instead, we're here doing this stupid stuff to try to get audio of a transcript we already have. And it gets even worse than that. There is a second committee. The Oversight Committee is going to do an exact same hearing on this contempt proceeding. Let me just put in that, you know what, at least the chairman of that committee did not ignore a congressional bipartisan subpoena. It might be more appropriate for that committee to do it, and we should end this proceeding right now. I yield back.
Gentleman yields back. The gentleman from Texas is recognized.
Thank you, Mr. Chairman. After that 5 minutes, I was starting to get a little sleepy. I would like to yield my time to Mr. Vandrew.
I thank the gentleman for yielding. Man, here we go again. So the gentlemen, my friends from Tennessee and California and Maryland, they want us not to have our eye on the ball. They want us to look, and we talked about this before in this committee, the shiny object over here. When you're really in trouble on the other side of the aisle, when you've really got a problem, let's go after Donald Trump. Let's make it a campaign stump speech. Let's talk about what a bad guy is. Let's talk about all these different issues. That's not why we're here. That's it. Again, if we want to have a separate debate, a colloquy, a discussion, formal, informal, we'll do it, man. I'm ready to go at it. I think most of us here are. But that is not the issue. The issue is this committee feels that it needs an audio transcript because the charges, the concerns are so serious. I want everybody to understand, we're either saying that our current president is cognitively impaired, incompetent, unable to stand trial, even though he broke the law. So the Department of Justice decides that they won't go after him for those reasons. And if that's true, we need to hear the audio tape. You're going to be able to understand if he truly is that cognitively impaired, if he truly has those problems, if he cannot deal with these issues, if he didn't know what he is doing. We are going to learn a lot more. And by the way, if it's no big deal, as the other side says, because we have the transcripts, well, we do have the transcripts, so why do you care so much about us getting the audio? What's the big
Would
deal?
the gentleman yield for an answer?
I just want to finish this first. I will yield. We already have the transcript, so why don't we have the audio? Because we can find out whether he is in that much trouble, if the country is in that much trouble. This has got nothing to do with what's going on in New York. This has to do with what's going on right here in the White House in Washington, D.C. with this president. Or if he is not cognitively impaired, if he is with it, if he is capable, then he broke the law as vice president and as a U.S. senator, not allowed to take these classified materials out, kept them in a garage by his home next to a collapsed dog kennel, and then used them. I want everybody to understand that. Then use them, read them to his ghostwriter to use in his multi-million-dollar book deal. Was he competent? Did he know what he was doing when he made this deal and used these papers to make money on the presidency? That's what we need to know. That's why we're going through all this. It's got nothing to do with the other stuff. And that's what we need to find out.
The gentleman yield now.
And that's why, I will, in one moment, and that's why we're having this discussion, because this committee has an oversight responsibility and needs to know that. But it's not only the committee. Most importantly, the American people need to know it. We need to know if we have an incompetent, incoherent president, or if we have a president that is being helped through the two-tier system of justice, again, just like they tried to help his son. Justice for thee, not for me. God help us, the American people, whomever are watching and listening to this, don't have those opportunities, but he keeps getting them over and over again. Which is it? I know it's a bad spot for you folks. I get it. It's a really uncomfortable place to be. But we need to find out the truth. And I yield to the gentleman from Cal. Actually, I'll yield to you, the gentleman from California.
Thank you. I just want to comment the following. The special prosecutor decided that there was no reason to prosecute for his own good reasons. He stated them in his report. He made what I regard as a gratuitous smear of the president by his comment on cognitive impairment. We will see. We don't need the transcript to see if the president is cognitively impaired. The president speaks all the time. There are going to be two debates. The American people can decide whether the president is cognitively impaired. They can decide whether his opponent is cognitively impaired. They're going to see plenty of evidence of that in the debates and in the campaign. So we don't need the transcript to know whether the president is cognitively impaired or not. The evidence is going to be before the American people.
I reclaim my
thank the gentleman for yielding.
I reclaim my time. And look, this doesn't have anything to do with the debates, though. I get it, and I know everybody's going to enjoy them, me included. But this has to do with the actions that took place regarding classified materials. And either, as the special prosecutor said, he is cognitively impaired and unfit for trial, or he knowingly did this and made money off of it. I yield back to Mr. Nels. I think Mr. Nels yields back to you.
Gentleman yields back. The chair recognizes the gentleman from Georgia.
Thank you, Mr. Chairman. This hearing is a continuation of what this Congress has been about under Republican authority since January 3rd of 2023. We started out trying to elect a speaker. It took, I think, 19 ballots before this Congress, back in 2023, January, was able to elect a speaker. And then that speaker presided over what is agreed upon by most people who are observing this committee's functions this Congress's functions. This has been the least productive Congress in the history of the country, many are arguing. And my friends on the other side of the aisle on this committee are a part of that. They have spent $20 million investigating President Trump. This committee alone has spent $20 million during this 118th session of Congress, which began in January of 2023, investigating President Biden. They suffered the indignity of their leader, former President Trump, being indicted for withholding classified documents. That indictment was in July of 2023, during the height of this do-nothing Congress, and not long before this Congress expelled the Speaker. It took so long to elect in January. They put him out in October. And then we went for 3 weeks while even people on this committee were vying for the speakership. It took 3 weeks and ran through a number of candidates before this Congress elected Mike Johnson as its speaker, formerly of this committee. And he has not fared much better. Neither has the House under his reign. Still nothing accomplished, and we get to this point now where after spending $20 million, this committee has absolutely nothing to show for it. They tried to pin a classified documents case on President Biden. They had a special counsel Herr, who spent a lot of money investigating, couldn't find a thing, had to write a report that cleared the president from illegally withholding classified documents. And then he was summoned to this committee to deliver the findings of his report, which included a derogatory reference to President Biden being having a loss of memory, disparaging him. And that was the only thing that Republicans could get out of Herr's report. And so they made hay of that for a while, and then that went away, and now it has come back. We're seeking to hold the Attorney General in contempt of this committee for refusing to produce an audio file. When you already have the voluminous document, the entire unredacted Herr report, the transcript of the interview with the president, even talking to the president's ghostwriter. It was an exhaustive investigation. And the only thing we can do now is come up with additional information to show that Biden is cognitively impaired. That's what this committee is trying to do today, according to my friend from New Jersey, get the evidence that Biden is cognitively impaired. So this is political. It's a do-nothing Congress. It's the product of a do-nothing committee. The American people deserve more, and they're seeing what's happening. And I think they're going to sweep this committee out of its perch, and Democrats will be back in control so that we can do the work that the American people need us to do, to keep them safe and to make sure that costs are down, make sure that our economy is humming along, jobs, rebuilding America. That's what this committee needs to be about, not a fishing expedition trying to show that this president is cognitively impaired. And with that, I yield back.
Gentleman yields back. The gentleman from Wisconsin is recognized.
Thank you, Mr. Chair. I mean, a lot of us sit here and we listen to the special counsel, I think, respond to many questions that day, sitting right there in front of us. And I began to wonder kind of what were the conversations behind closed doors? What were the discussions amongst the attorneys on how are we ever going to dismiss the idea that the President of the United States holding substantial positions within our government had absolutely secured on his own person sensitive documents and then was able to take them back to his residence, move boxes of them to offices in multiple locations, and obviously willingly and knowingly mishandling secret, sensitive U.S. government documents and just dismiss this. And there had to have been a conversation with the special counsel behind closed doors about, well, let's see, they just did a raid on the former president's home in Florida, lights going, securing specific areas of that residence, and really kind of ransacking the place. And now we find out, probably, a little bit of orchestration on what they wanted those documents to look like when the photos were taken. But I can't imagine what the special counsel and his assistants were trying to dismiss by simply saying that the president, he's not all there. And we've seen it on TV. We see it every day now. He's completely incompetent from handling a simple press conference. So that became their way out. That became what they thought could justify letting him off the hook. And I'm not sure where that would have gone as a criminal prosecution. None of us are ever going to know that, right? I mean, my own personal opinion is that Herb blew it, because he's the one who set up this juxtaposition of the President of the United States, who, by the way, just agreed to 2 presidential debates, okay? But at the same time, we're supposed to believe that, he had a few boxes in the garage and he lost track of them, and he's just not up to standing trial for this. He's just not up to actually having an attorney ask him poignant questions about what he was doing with the documents. And was he aware what were in those boxes that he had all over the place? And now, today, we get a letter from Mr. Siskel. So again, I wonder what was going on behind closed doors at the White House yesterday in the discussions on how are we now going to make sure that we protect the president again from having to disclose anything of substance. And the paragraph that strikes me is, the absence of a legitimate need for an audio recordings lays bare your likely goal. Now they're telling Congress what our goals are in trying to secure evidence. And that is to chop them up, distort them, and use them for partisan political purposes. Okay, and that's not part of our process either, right? That you have to run for re-election. So if something like this was actually utilized in that way, which that is not the committee's intent, but clearly one of the attorneys over at the White House dropped the ball when they wrote that paragraph. Because it just went from us not being able to do oversight to now we've come up with a way that we're actually going to execute a little bit of a cover-up. We're going to move towards cover-up to make sure that the special counsel's conclusions are not questioned beyond what was done in this room when he was here a month ago. So, Mr. Chairman, this entire day is not only warranted, but the American people see what's going on here. We're not going to elect Donald Trump. The other side of the aisle in the White House is going to elect Donald Trump. And I yield back.
Gentleman yields back. The chair now recognizes the gentleman from California, Mr. Swalwell.
Well, it's nice to see that some of my colleagues on the other side could make it today. I don't know if that means that there weren't enough seats in the courtroom in New York, but I know that the Oversight Committee canceled a hearing that was supposed to happen right now on this matter so that they could be at the president's trial. I know some members will miss this vote because they want to be at the president's trial, and I don't think that anything could animate the phrase, "do nothing Congress," more than missing votes and canceling hearings to go up and be a spectator at your cult leader's trial. That is the definition of do nothing Congress. But I'm here for a celebration because, let's raise a glass, it's been about 2 years this week. May 12 is when Jim Jordan, our chairman, was subpoenaed and asked to comply with his subpoena for his role, his interaction with the former president on the January 6th attack of the Capitol. And so we are now 735 days in. It's 2 years, and this committee has the nerve, this committee has the temerity to seek compliance from the Attorney General. I actually think you should not be able to bring any subpoena of another person if you are out of compliance of your own subpoena. That seems to make a lot of sense to me, and we'll have an amendment to address that a little bit later. But I want to talk about this particular effort to hold the Attorney General in contempt, because what is this really about? After all, it was Donald Trump's appointed prosecutor who the Attorney General deputized to be the special counsel here to look at President Biden's handling of classified documents. So it was Donald Trump's prosecutor who cleared President Biden. He said, there's nothing to see here. And in fact, although he did not put it in the lead memo for his report, there was an exchange that he acknowledged in the interview with President Biden where the special counsel told the president, your recall is photographic. He didn't say your recall is good. He didn't say your recall is decent. The special counsel said, your recall is photographic. So what is this really about? This is about you all not accepting the outcome of the 2020 election. You rooted on the rioters as they sought to attack the Capitol on January 6th. If that wasn't enough, you all went back to the floor and relitigated the issues that brought the rioters to the Capitol just 8 hours later. Many of you go and visit the convicted criminals who assaulted the police officer at their jail cells. And during Police Week, as a bunch of officers yesterday testified in the Homeland Security hearing that those officers are heroes and those rioters are criminals, you call them hostages. And the former president calls them hostages. So this is entirely about not accepting the outcome of the January 6th vote here, rooting on the rioters, and doing everything you can to try and affect the outcome of the upcoming election. And so then I thought to myself, is there like a parallel? Is there another investigation where your side was completely incurious about what that investigation yielded? Turns out there was. Turns out it happened recently. Turns out somebody on your side was investigated for sex trafficking. Now you're going to say, well, he was cleared. They dropped the charges. Yes, the Biden Attorney General dropped the charges, didn't pursue, didn't bring charges. That's exactly what happened with President Biden. But you all have shown no interest to go to the Attorney General and say, well, we want to learn more. We want to see the notes and the audio recordings and the evidence of our own colleagues' sex trafficking investigation. Not a peep from any one of you. So if you wanted to do that, if you wanted to show just a little bit of consistency, I would be willing to entertain that you have a genuine interest in understanding what happened in that hearing. But that's not what this is about. This is about doing everything to help Donald Trump, who you see as your client, who a New York criminal trial sees as a defendant, to help him win an election. So I have no interest in playing this game. The American people have no interest in playing this game. And all this does, for those of you who have graced us with your presence, animates that it's a completely do-nothing Congress. And I yield back.
Gentleman yields back. Gentleman from Texas is recognized.
Thank you, Mr. Chairman. I'd yield to the gentleman from California.
I'll be very brief before my colleague from California leaves. I've been on this committee long enough to know why we mark up contempt. This committee and the committee that he referred, oversight, we've held people in contempt for not doing things. This committee successfully held in contempt the chief counsel to the president under George W. Bush for not showing up. We, next door, held in contempt Eric Holder for withholding information that he said he had 200 and some pages. Ultimately, over 10,000 pages turned out to be delivered. What's interesting and very similar is the president's old boss, President Obama, claimed executive privilege on exactly the day we were about to do this. And ultimately, none of those 10,000 pages stood the test under a judge appointed by President Obama for executive privilege. So the false claim of executive privilege today is just as much a ruse as it was under President Obama. And that's the piece of history that I hope my colleagues will observe as we hold this Attorney General in contempt. And I thank the gentleman for yielding.
Yeah, I thank the gentleman. I mean, I would note that my colleagues are decrying the fact that some of our colleagues are in New York. But let's remember what's happening in New York. We have a clear sham trial being perpetrated by a judge with clear bias. We have a situation where the entire thing relies on Michael Cohen, who, I mean, just to say the least, is a convicted felon, has been disbarred, has pled guilty to perjury and various financial crimes. The judge, his own daughter, is a known Democrat political operative, has clients, including some of our Democratic colleagues, I think even on this committee, including some Democratic colleagues who are in fact advising Michael Cohen at this particular moment. All of that is occurring at a time when they're calling Michael Cohen when they could bring forward Alan Weiselberg, who is sitting over in Rikers, but for some reason they're not bringing him forward, which one could guess because it wouldn't help. And the fact is, this is all playing out while bootstrapping a federal law into a state crime in order to try to navigate statutes of limitations. It's ridiculous. I mean, it's patently absurd what we're seeing unfold with our system of justice, the politicization of it. And now here we sit, and my colleagues on the other side of the aisle don't like that we simply want to see the best evidence available when in fact it is not, as one of my colleagues talked about, trying to effectively get a second stab at criminal proceedings. This is an impeachment inquiry. That is inherently not a criminal proceeding. It is a unique function of Congress under the Constitution of the United States. And we're investigating very legitimate questions, conflicts of interest of the Biden family, the significant amount of money that has flowed to the Biden family, the extent to which the president has had material that he's not supposed to have in his possession, which the special counsel firmly pointed out, and in fact, in this committee, testified to. And in fact, the president and his lawyers have contested Special Counsel Hur's assessment. But the truth is, Special Counsel Hur in this committee stood behind his sworn testimony. We've got evidence that we can see in transcripts, but all we're pointing out is it is a both impeachment function and legislative function of this body to be able to use the power to be able to go to the Department of Justice, which is supposed to be overseen by us in the first place, by the way, and to say, we simply want to see the best evidence because if you look in the terms of the criminal proceeding, which is not an impeachment inquiry, and is not the legislative function. It is an independent, unique function in the criminal inquiry that they're carrying out at justice. That clearly what you saw from Special Counsel Hur was a great deal of dependence on the demeanor of the president. An extraordinary amount of dependence in terms of his determination on whether to pursue charges depended on how he assessed the demeanor of the President of the United States. That's all this is about. It's not political. It's not about something that might show up later for political purposes. It is very much to the heart of whether or not and what the president knew about the materials that he had, which the special counsel firmly acknowledges and wrote were illegal for him to possess. And the question is what was his intent? And it is critically important for the purposes of this body to determine where we're going to go with an impeachment inquiry or any legislative inquiry to determine what the president's demeanor was during that interview. I yield back.
Gentleman yields back. Gentleman from Virginia is recognized.
Thank you, Mr. Chairman. You know, I'm disappointed. Moved to strike last word.
Was recognized.
I'm disappointed, but I'm not surprised that we're getting a letter from the White House citing executive privilege the day before the hearing, the day before the markup. And as my colleague from California knows, who's the ranking member on the subcommittee that I chair, Responsiveness and Accountability to Oversight, this is common behavior for this White House. Wait until the last minute and then throw either an excuse or a few pages of documents that have been subpoenaed, much of which is publicly available, to us to try and fend off exactly this, a contempt citation for failure to comply. You know, it'd be one thing if it were the subcommittee that I chair. It'd be one thing if it were documents subpoenaed at the Department of Health and Human Services or Education or the FTC about collusion with big tech, about the COVID information that they tried to limit availability on the internet. There are so many different ways in which this administration has failed to be accountable, failed to be held accountable, and failed to provide the information that we've requested, that we're not surprised. But this is under an impeachment inquiry. Last year, we approved an impeachment inquiry in this body, which heightens that standard and actually increases the burden on the administration to show that there is some reason why they should not be providing this information. And executive privilege is not applicable here. We have a request for a recording. As was stated earlier, the White House doesn't get to decide how that information is provided, which transcript is better, which transcript is appropriate. If we want one transcript, they give us that one. If we want the other one, they have to give us that one. This investigation is about whether the president willfully retained and disclosed classified materials after his vice presidency when he was a private citizen. Actually, that was a conclusion. And then Hur's investigation also concluded that Vice President Biden had, quote, strong motivations, unquote, to ignore the rules for properly handling classified materials. Those strong motivations included an advance of $8 million that Biden had planned to receive for writing his memoir, a book he had decided to write, quote, months before leaving office. But why has the DOJ not sought to bring charges against the president for his actions, both as vice president and a private citizen? Well, for one reason, Special Counsel Hur noted in his report that although there was sufficient evidence that Biden had willfully retained classified information, he wouldn't recommend taking it to trial because the president would appear to a jury to be, quote, sympathetic, well-meaning, elderly man with a poor memory. But Hur knew that to make the $8 million book advance, he would need reminders. but many of those reminders are classified, and yet he shared them with his ghostwriter, Mark Zwaneder, who holds no security clearance. As part of the impeachment inquiry in the Judiciary Committee's legislative oversight, the committee has sought information about, among other things, President Biden's mishandling of classified information. And the DOJ refuses to provide the committee with these recordings. And Attorney General Garland not only confirmed that this material has been turned over to the White House and not us. He said this during an appropriations testimony, but failed to see the hypocrisy in allowing the White House access to these recordings, but not the Judiciary and Oversight Committees. So he rejected the notion that DOJ should release the recordings and said they needed to remain confidential, but at the time had no response as to how to provide the recordings to the White House, as to how he provided the recordings to the White House. So these recordings are important to our investigations because of the superior evidence that the transcripts, the recordings provide, because transcripts do not capture demeanor evidence. And there's evidence that the White House has doctored official transcripts to hide a verbal slip-up from President Biden already. So if they're already doctoring official transcripts, we need the tapes. We need the tapes, and they have an obligation to provide them to us. I yield back.
Gentleman yields back. The question occurs on the amendment offered by the gentleman from New York. Those in favor say aye.
Aye.
Those opposed, no.
No.
Opinion of the chair, the noes have it, and the amendment is not agreed to. The roll call being requested, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Mr. Moran votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Bush? Mr. Ivey?
Aye.
Mr. Ivey votes aye. Ms. Ballant? Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Fitzgerald votes no. Mr. Gooden votes no. Mr. Fry votes no. Mr. Chairman, there are 8 ayes and 17 noes.
Noes have it, the amendment is not agreed to. Gentleman from Georgia.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from California.
Amendment to the amendment in the nature of a substitute. To
Objection, the amendment will be considered as read. The
I
gentleman.
object, Mr. Chairman.
Okay. Clerk Clerk will read the amendment.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Merrick B. Garland in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary, offered by Mr. Johnson of Georgia. On page 13, at the end of the second full paragraph insert, the committee also notes serious concerns about the competency of Donald Trump. The weekend before the committee took up this contempt report in a speech delivered in Wildwood, New Jersey, Mr. Trump praised the fictional serial killer from Silence of the Lambs, quote, the late, great Hannibal Lecter, he's a wonderful man, unquote, and, quote, congratulations, the late, great Hannibal Lecter. We have people that are being released into our country that we don't want in our country, end quote. Mr. Trump also confused the Chinese city of Beijing with the self-governing island of Taiwan and confused the famous tennis player Jimmy Connors with President Jimmy Carter. At a rally in Iowa last January, Mr. Trump declared, think of it, magnets. Now, all I want about magnets is this. Give me a glass of water. Let me drop it on the magnets. That's the end of the magnet. During a series of March campaign rallies, Trump mistook the country of Argentina for a person telling the crowd, you know, Argentina, great guy. He's a big Trump guy. He loves Trump. I love him because he loves Trump. Anybody that loves me, I like them. He also claimed that a poll was a legislative bill called our country the United Stage and made a series of unintelligible noises when describing himself. Ding, boom, this is me, unintelligible, bing. It is not even clear if Mr. Trump knows which of his political opponents he is running against. Mr. Trump has mixed up President Joe Biden and former President Barack Obama on at least 8 different occasions. He confused presidential candidate Nikki Haley with former Speaker Pelosi, inferring that Ambassador Haley was responsible for Capitol security. Mr. Trump has also been confused with respect to foreign leaders. For example, in October 2023, Mr. Trump referred to Hungarian Prime Minister Viktor Orban as a great leader of Turkey. These examples and more raised serious concerns about Mr. Trump's mental competency and ability to serve another term as president.
Gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman,
The gentleman.
This contempt report that is being considered today is chock full of misleading references to President Biden's age and his mental competency. And throughout this hearing today, I've heard the false allegation made that Special Counsel Hur found that Biden was incompetent to stand trial. That is not what Hur found. He simply questioned the president's memory. And so let's not get it twisted. And speaking of, cognitive impairment, the report that we're considering today conveniently omits serious evidence that the standard bearer for my friends on the other side of the aisle, Donald Trump, is the only candidate who shows any evidence of competency problems. Just this past weekend, in a speech in Wildwood, New Jersey, Mr. Trump bizarrely praised a fictional serial killer from Silence of the Lambs, the late, great Hannibal Lecter. He's a wonderful man, is what the president said. And congratulations, the late, great Hannibal Lecter. We have great people here that are being released into our country. We don't want our country. We don't want in our country. Hear it for yourself. Play the tape.
Silence of the Lamb. Has anyone ever seen The Silence of the Lamb? The late, great Hannibal Lecter. He's a wonderful man, President Xi of China, talking about Beijing. Now, they've got ships circling, they have planes, but they never were doing anything. I could have pressed Hillary a lot harder. You know, she broke up her phone, she broke them up, she acid washing. Bit bleach, right? Bit bleach. Nobody even knows what it is. All done by Biden. Carried out by Ray. That's right. Jimmy Connors is Jimmy.